Last part of our reconveyance case. Okay, arang-arang na akong pamati. Spouses aboitis argue that the Mariano heirs are indispensable parties who should have been impleaded in this case. Dapat gihinganlan sila appeal as parties sa kaso. The Mariano heirs are not indispensable parties. Rule 3, Section 7 of the Revised Rules of Court provides ano siya ang provision sa Rules of Court aning kasuha sa panahon aning kasuha unsa ang compulsory joinder of indispensable parties. Kanus kailangan i-appeal ang usa ka tawo or person of natural person or artificial person, the corporations, to be a party to this case. Kailangan i-appeal, no? Parties in interest without whom no final determination can be had of an action shall be joined either as plaintiffs or defendants. Parties in interest, no? Mga tao, party nga na ay makuha nga benefit or mapildi silang maka-experience of prejudice or maka-experience of damage sa epekto sa kaso or maka-experience of benefit sa epekto sa kaso. Parties in interest without whom, kung di sila apilon, walay final determination, dili mahusay, permanente, and fully ang kaning gilalisan sa plaintiffs o sa defendants, kay kailangan sila apilon jud sa kaso. So, parties in interest without whom no final determination can be had of an action shall be joined either as plaintiffs or defendants. Basig di kay accurate ang ako ang translation sa Bisaya, ha? Lisod sa siya translate. An indispensable party, ang party nga kailangan jud apilon, is the party whose legal presence in the proceeding is so necessary. Party ni siya nga ang iyang presensya sa kaso necessary kayo, importante kayo. important ba no? Necessary. Kinahanglanon kayo that the action cannot be finally determined. Ang kaso dili ma-determine ang ending fully and finally without him or her because his or her interests in the matter and in the relief are so bound up with that of the other parties. Mga nakalumpong kayo ba? The property owners against whom the action for reconveyance is filed are indispensable parties. No relief can be had and the court cannot render a valid judgment without them. The property has been sold to respondents, Jose, Ernesto, and Isabel. Thus, they are indispensable parties. However, the seller of the property is not an indispensable party. In another case decided by the Honorable Supreme Court, cited in this decision, similarly, by virtue of the second deed of absolute sale between Spring Homes and the spouses Lumbres became the absolute and registered owner of the subject property herein. As such, they possess that certain interest in the property without which the courts cannot proceed, for settled is the doctrine that registered owners of parcels of land whose title is sought to be nullified should be impleaded as an indispensable party. Spring Homes, however, which has already sold its interest in the subject parcel of land, is no longer regarded as an indispensable party, but is at best considered to be a necessary party whose presence is necessary to adjudicate the whole controversy, but whose interests are so far separable, pwede mabuwag, that a final decree can be made in its absence without affecting it. So, kung pwede siya mabuwag, kay layo ra kaniyang issue dire, iyang interest, mahimo ra siya nga dili siya matawag nimo nga indispensable party. Sa aning kasuha, necessary party lang daw. In fact, a new title was already issued in the names of the spouses Lumbres. As such, Spring Homes no longer stands to be directly benefited or injured by the judgment in the instant suit, regardless of whether the new title registered in the names of the spouses Lumbres is cancelled in favor of the spouses Tablada or not. Thus, contrary to the ruling of the Regional Trial Court, The failure to summon Spring Homes does not deprive it of its jurisdiction over the instant case, for Spring Homes is not an indispensable party. In this case, the Mariano heirs as the alleged sellers of the property are not indispensable parties. They are at best necessary parties which are covered by Rule 3, Section 8 of the Rules of Court. Ilang rule at the time of this case? Section 8, necessary party. A necessary party is one who is not indispensable, but who ought to be joined as a party if complete relief is to be accorded as to those already parties, or for a complete determination or settlement of the claim subject of the action. Necessary parties may be joined in the case to adjudicate the whole controversy, but the case may go on without them because a judgment may be rendered without any effect on their rights and interests. Mariano heirs may likewise be considered material witnesses to the action. A material matter to which a witness can testify on can be a main fact which was the subject of the inquiry, or any circumstance or fact which tends to prove the fact subject of the inquiry, which tends to corroborate or strengthen the testimony relative to such inquiry, and which legitimately affects the credit of any witness who testifies. The validity of the deeds of sale allegedly executed by the parties in this case is a material matter in determining who the true owner of the property is. Thus, the Mariano heirs, including Seriaco, may testify as to the deeds of sale they executed to prove which sale is the valid one. However, it is clear that the Mariano heirs are not indispensable parties. They have already sold all their interest in the property to the spouses appointees. They will no longer be affected, benefited, or injured by any ruling of this court on the matter, whether it grants or denies the complaint for reconveyance. The ruling of this court as to whether the spouses po are entitled to reconveyance will not affect their rights. Their interest has thus become separable from that of Jose, Ernesto, and Isabel. Di na sila mapiktuhan. Thus, the Court of Appeals correctly ruled that the Mariano heirs are not indispensable parties. Last part, hapit na jud. Despite these findings, the spouses po cannot recover the property. Respondents Jose, Ernesto, and Isabel are innocent purchasers for value. Buyers in good faith daw sila. An innocent purchaser for value refers to the buyer of the property who pays for its full and fair price without or before notice of another person's right or interest in it. He or she buys the property believing that the seller is the owner and could transfer the title to the property. The spouses po argue that the respondents Jose, Ernesto, and Isabel are not innocent purchasers for value because the tax declaration over the property has the following annotation. This tax declaration is also declared in the name of spouses po under a separate tax declaration number so that one may be considered a duplicate to the other. However, if a property is registered, the buyer of a parcel of land is not obliged to look beyond the transfer certificate of title to be considered a purchaser in good faith for value. Section 44 of PD 1529, Statutory Lens Affecting Title. Every registered owner receiving a certificate of title in pursuance of a decree of registration, and every subsequent purchaser of registered land taking a certificate of title for value and in good faith shall hold the same free from all encumbrances except those noted in said certificate and any of the following encumbrances which may be subsisting, namely, first, liens, claims, or rights arising or existing under the laws and Constitution of the Philippines, which are not by law required to appear of record in the Registry of Deeds in order to be valid against subsequent purchasers or encumbrances of record. Second, unpaid real estate taxes, unpaid real estate taxes levied and assessed within 2 years immediately preceding the acquisition of any right over the land by an innocent purchaser for value, without prejudice to the right of the government to collect taxes payable before that period from the delinquent taxpayer alone. Third, any public highway or private way established or recognized by law, or any government irrigation canal or lateral thereof, if the certificate of title does not state that the boundaries of such highway or irrigation canal or lateral thereof have been determined. Fourth, any disposition of the property or limitation on the use thereof by virtue of or pursuant to Presidential Decree Number 27 or any other law or regulations on agrarian reform. In another case decided by the Honorable Supreme Court and cited in this case, the real purpose of the torrent system of registration is to quiet title to land and to put a stop to any question of legality of the title, except claims which have been recorded in the certificate of title at the time of registration or which may arise subsequent thereto. Every registered owner and every subsequent purchaser for value in good faith holds the title to the property free from all encumbrances except those noted in the certificate of title. Hence, a purchaser is not required to explore further what the torrent's title on its face indicates in quest for any hidden defect or inchoate right that may subsequently defeat his right thereto. Where innocent purchasers for value or innocent third persons relying on the correctness of the certificate of title thus issued acquire rights over the property, the court cannot disregard such rights and order the total cancellation of the certificate. The effect of such an outright cancellation would be to impair public confidence in the certificate of title. For everyone dealing with the property registered under the torrent system would have to inquire in every instance whether the title has been regularly or irregularly issued. This is contrary to the evident purpose of the law. Every person dealing with registered land may safely rely on the correctness of the certificate of title issued therefore, and the law will in no way oblige him to go behind the certificate to determine the condition of the property. Even if a decree in a registration proceeding is infected with nullity, still, an innocent purchaser for value relying on a torrent's title issued in pursuance thereof is protected. The rationale of this rule, for this rule, is the public's interest in sustaining the indefeasibility of a certificate of title as evidence of the lawful ownership of the land or of any encumbrance on it. In another case, the torrent system was adopted to obviate possible conflicts of title by giving the public the right to rely upon the face of the torrent certificate and to dispense as a rule with the necessity of inquiring further. One need not inquire beyond the four corners of the certificate of title. Matod nila, kanang papel, sipon mo kay. Mora ni mo tanawon ang titulo, no? Di ka kailangan mo tanaw beyond sa titulo. Pero careful ani nga rule, ha? Kay daghan po na disgrasya ani nga ma-considered sila nga buyer in bad faith. So, this rule, kaning definition sa buyer in good faith, discuss this with your lawyer kung mopalit ka og property. Kay daghan ni og mga nitty-gritty. Kailangan nimo ni ma-apply or ma-follow properly ang requirements in order to be a buyer in good faith. One need not inquire beyond the four corners of the certificate of title when dealing with registered property. The protection of innocent purchasers in good faith for value grounds on the social interest embedded in the legal concept granting indefeasibility of titles. Between the third party and the owner, the latter would be more familiar with the history and status of the titled property. Consequently, an owner would incur less costs to discover alleged invalidities relating to the property compared to a third party. Such costs are, thus, better borne by the owner to mitigate costs for the economy, lessen delays in transactions, and achieve a less optimal welfare level for the entire society. Thus, respondents were not obliged to look beyond the title before they purchase the property. They may rely solely on the face of the title. The only exception to the rule, the exception, is when the purchaser has actual knowledge of any defect or other circumstance that would cause a reasonably cautious man to inquire into the title of the seller. If there is anything which arouses suspicion, the vendee is obliged to investigate beyond the face of the title. Otherwise, the vendee cannot be deemed a purchaser in good faith entitled to protection under the law. In this case, there is no showing that the respondents Jose, Ernesto, and Isabel had any knowledge of the defect in the title, considering that the annotation that the spouses po are invoking is found in the tax declaration and wala dito sa titulo, nara sa deklarasyon ng iyang annotation and not in the title of the property. Respondents Jose, Ernesto, and Isabel cannot be deemed purchasers in bad faith. Considered sila as buyer in good faith. Wherefore, the Court of Appeals decision and its resolution is affirmed. Nahuman na dyan. No? So, nindot ni siya nga area. Ako rin basa ako balik. Nindot siya, yung explain ang clear boundary ba? When ka considered as buyer in good faith, when ka considered as buyer in bad faith. Okay? So, I'll see you in the next video.